we're going to continue our dialogue about legalese and deal with some really critical aspects in what addresses really most Americans in the aspect of at-will employment. When we talk about at-will employment, if you look overall in our population in the United States, at the time of this recording, less than 10% of all Americans are covered by a union. That means 90% are not. So that means 90% of Americans are at-will employees, the ones that are working. So when you have that, the employment relationship, there's no contractual relationship to remain for a defined period. You don't have to, I must honor this. You have to sit here and work for 2 years before I can do anything. No, you don't have that. It goes back to the origins of the English feudal system, and really its roots are there about the aspect of, I want to work for you. Will you hire me? Yes, I will. I will hire you at this rate, give you these benefits and this opportunity. In return, I want you to sit down and do the work over here for X number of hours, or do this type of work and complete this contract, complete this obligation over here. So you have this really, in theory, it should be a mutual relationship. The employee can walk away from the job because they don't like the worker, they don't like the work, they don't like the work environment, or because they don't want to. The employer can also walk away from the relationship saying, I really don't like this person, I don't like the work they're doing, their quality, or I don't want to do this anymore. So they sit and get rid of the employee. Both sides can terminate either party, just not for a reason that's a bad one. We'll talk about a bad one in just a minute. If you look on the aspect, the balance between an employer and employee, when you have almost 80% of all the revenue generated by a corporation, corporations can be very big, and corporations have an entire regime of people that can be pitted against one individual. So you have all that aspect of it. Instead of employment at will being symmetrical with a balance between the employer and the employee, you really have an overbalance that gives an advantage to the employer. So if the employer has a whole battery of people in human resources, they have lawyers and everything else, if there's ever a lawsuit in the process, the chance of one individual defeating the other one is slim. So there are some different actions that are defined by the courts in regards to at-will employment and the aspect of making certain that there's a balance to the whole aspect of it, and they shouldn't have a bad reason for terminating somebody. And we'll talk about bad reasons in just a moment. There's 10% of the American population covered by a thing called a collective bargaining agreement, because the employees are represented by a union, and the union has come forward and they negotiated and put these in your notes. There are 3 things that federal law provides that a union can negotiate for. Wages, number 1, hours, number 2, and 3, working conditions. Wage, hours, and working conditions. Those are the 3 things that a union has a legal right based upon federal law to bargain for. So once they negotiate all that, they'll have a collective bargaining agreement. Sometimes in slang we call it a CBA, or we call it the contract, or a labor agreement. There's a lot of terms for it, but it all refers back to the document where the management has agreed to this and the employer's union has agreed to this, and you have to sit down and have that balance in there. Every single collective bargaining agreement, at least the ones that I've ever heard of or read, they all have an aspect of disciplinary action, how to go about doing that. So that's part of the aspect of what's involved in negotiations. It'll limit the employer's discretion for just cause terminations. They'll define it sometimes, actually put it in writing. If they do the following 17 things, any one of them are grounds for termination. Okay, so you have that aspect of it. So you'll have the aspect of sometimes the duration of employment. You'll have individual contracts. In large corporations, almost every chief executive officer and a lot of your C-suite executives, we call them the C-suite because it's the chief human resource officer, the chief business officer, the chief marketing officer, the chief IT officer. You'll have a lot of chiefs there. The bulk of them will have an individual contract that defines their scope of their work and also their compensation and also the limitation. This is for 3 years. And at the end of 3 years, the company doesn't have to renew that contract. So sometimes you'll have individuals with contracts of their own between them and the employer. You'll see that in all professional athletes. They all have the spectacular contract and they get paid, and they'll have all kinds of different things. If this happens and this happens, this happens, you'll get these bonuses and so on. So you'll have that aspect happening over there. But really, we're talking that's about 10% of all the different things that are part of a union, and a small percentage that'll have individual contracts. A lot of times, that if you look as to what happens for termination and dismissal, you might have the aspect of wrongful termination or unjust dismissal. Well, okay, if you look at the record, you'll see that about 2/3, 67% of all lawsuits that happen between an employee and an employer, they come from how somebody was released. You know, here, this thing almost goes above the aspect of employment law. Everybody should be treated with dignity and respect, including for formal disciplinary action, including for termination. I've had people come to me after they were terminated and apologize for the behavior that they did in the workplace. And here's a simple reality about it. You don't attack a person in any kind of termination. You don't attack the person's character. You don't attack anything about who they are. You attack the behavior that was performed. That is what you're paying them for, and that is what you should be expecting, and be clear what that's about. If you do that, you're going to have, number one, you may have no problems in dismissing people, but you might be able to sit down and not have to go to that extreme with just some aspects of correcting inappropriate behavior in the workplace. Regardless, if you're involved in a court case, they're going to be suing for two different things. They're going to be suing for compensatory damages. In other words, make the party whole. What does making the party whole mean? I've been gone for 18 months. I want to get paid back all the money that I lost if I'd been working. I want to get the benefits, and I want my contribution to my pension plan. I want all this. And so that's all compensatory damages. Your damages that you missed because of the fact you weren't working. The other one is punitive. And this should never have happened in the workplace. I want to have $10 million on top of all my compensatory damages. Well, now you're going to punish them for the way they behave. So compensatory, you're restoring them, making the injured party whole, and that's a term that we use. And then punitive damages, that intends to punish the wrongdoers and make certain other people see what it is inappropriately to punish them, and that's called punitive damages. And it's going to really, this aspect of recognitions of exceptions to the doctrine of employment at will, it's going to change from state to state to state to state. You'll see that between them, and it just depends as to how much the legislature has got involved in this relationship between the employer and the employee. But regardless, bad faith, malicious, or retaliatory termination can serve as a violation of what we call public policy. Bad faith, somebody reports a safety hazard about a product that you're selling and you fire them, you might have a problem there because of the fact that I'm not certain that if I were purchasing something that had a safety defect in it and the employer knew about it, then I would sit down and I would probably sit down and consider that aspect too. But the reality of bad faith, malicious, retaliatory for whatever, all those things, as soon as you start getting into these areas where a normal person would view that as inappropriate or bad faith, malicious, or retaliatory, then all of a sudden you start going into the realm of potential lawsuits. So with that, a termination in breach of some kind of implied contract. Okay, now if you have an employee handbook and the employee was abiding by everything in that employee handbook and they're terminated, you have an implication of a contract with the employee handbook. It's called an implied contract. So with that, if everything is followed and all of a sudden you're firing them because, with no specific aspect of it, you might have a problem. So termination in violation of the doctrine of what we call promissory estoppel, okay, that's where the employee relied on the employer's promise, and that was broken by the employer. Be careful on that. Here are some terms that you have to know, not just for this class, but also if you're in leadership in any organization. At-will employment, that really comes down to you have an agreement between the employer and the employee to work, and here's your compensation packages and so on. A collective bargaining agreement, wage, hours, and working conditions will be defined in there, usually quite a bit more too, but that is if you have a union. Just cause. have a reason to sit down, and you're going to terminate somebody or discipline them. Have a reason, some kind of just cause that you can back up. I've stopped terminations because of the fact that the supervisor didn't have just cause. They just didn't like them, and that was not part of the aspect because it would violate different protocols that we had between policy, procedure, and methodology as to how you treat people. Due process, we're going to cover that later on in much detail, but due process, if there's going to be some type of punishment over inappropriate behavior, it should be really the aspect of what is expected and so on. If somebody's coming in late, do you fire them because they missed coming in one day and are 15 minutes late? That doesn't seem to be just, and you should go through some type of due process of talking, counseling, and maybe reprimanding in the process. Compensatory damages, you want to sit down there and make a person whole, and know that terminology. Punitive damages, know about the concept of bad faith, malicious, or retaliatory termination. Make certain that whatever you do, you don't want to pursue a lawsuit. You shouldn't be afraid of them either. You need to do what is in the best interest of the organization, but make certain that a normal person would be able to look at that and know that that was appropriate to do that. If you have that type of a basis for all your decisions, life will be good, and employment law will just be something that you follow on a regular basis because you're treating people in good faith. Take care.